Welcome everyone. This is the 5th week of the Ibis Prep MBE crash course. And today we're going to discuss real property. And begin by sharing my screen. And sometimes it takes a bit, but Grace, can you see my screen?
Yes.
Thank you so much. All right. So the morning lesson plan. This is something that I really want everyone to think about. We're not going to talk about it, but think about it. And this afternoon, come back with an answer. If not, I'll come back with one for you. But in my Florida bar prep class yesterday, everyone was assigned a rapper name and a corresponding album. And it is related to a legal concept. For example, we had someone called The Straw Man, and his album for Florida was abolished because the concept of the straw man has been abolished. So MC Strawman with his album abolished, and he'll maybe make a mixtape cover for us. I'll show you what mine looks like on the next slide. We did a 15-question quiz. It was pretty awesome. My class did really good. I've never had students this prepared at this point in studying. Usually people are freaking out, and right now seems like we're doing good, and that's good. Now we're going to do property. I think the wheels start to fall off for a lot of people, property and civil procedure. I think those are the two toughest subjects, and we're going to do them back to back in my course. So here we go. Same things for me, but this is my rapper name and my album. My name is Ill-Gotten Gains, and my album is Restitution. And that's kind of a concept that I think will be cool for the whole class. Whoever makes the best rapper name, album, and album cover gets a free 1-hour session with me. And that could be pretty valuable because I'll pick your brain and go over it. So I want to see next week some creative designs. Ill-Gotten Gains Restitution is what I came up with for myself. Nothing about my business. We're working. Mindfulness. I got a new picture. Come on, everyone. Let's do this. We can do this. Positivity is a real thing, and belief in yourself is powerful. The daily affirmation: I will do practice questions every day. I will do practice questions every day. I will do practice questions every day. That's something that a lot of people need to hear and need to tell themselves, because a day without doing any practice questions is not a good day. Practice questions, you could do them on your phone, you could do them on your computer, you can do them before bed, you can do them when you wake up, you can do them on the toilet, you could do them while someone else is driving, right? That's our daily affirmation. If you're on your phone scrolling through something that's not helpful, switch to practice questions, right? That's our daily affirmation. I will do practice questions every day, and I promise that's gonna bode well for you. Try to take note of yourself and how you're feeling right now, and take the steps necessary to prepare yourself to execute on test day. And you're a month away, so we can talk about that. If you want to reach out to me or anyone on the team, you can reach out to the Ibis Prep support line. We are here to help. Study strategy, literally the slide has not changed because the strategy has not changed. We're now on real property. I want everyone to focus on real property questions this week, right? My students that work with me individually, my students in the class, I think this is a great week to try to master property, which is indeed a very tough subject. Here's some stats by property. At least property is well distributed, right? 20% ownership of property, 20% rights in property, 20% real estate contracts, 20% mortgages and security devices, 20% titles. I'm gonna go over my PowerPoint today. It's tough to do real property because there's so many different concepts. So I want this to be interactive. If I do a slide and you don't understand something, please pick my brain. I come from a family of real estate attorneys. My uncle is a very, very well-renowned construction law attorney. Some of these issues I know really deeply, so I'm happy to go down rabbit holes with any of you if we have time. So let's begin with fee simples, right? Does everyone know what a fee simple is? From A to B. Now B has a fee simple. When you have a fee simple, it means that there's no event or anything that can take that from you. You have absolute ownership of the land. If someone transfers land to me and says, Andrew, I give you this fee simple, but you can't sell it for the first 3 years, that's probably an unlawful restraint on alienability, right? When you have fee simple, you have the total right over that land. You are the lord of the land. That's what a fee simple is. Any questions with fee simples? I don't think there would be. It would be A to B or A to B and his heirs. B and his heirs assumes fee simple, right? It could, because when B dies, it will go to his heirs. Then we have defeasible fees. 3 types of main defeasible fees: fee simple determinable, fee simple subject to conditions subsequent, and fee simple subject to executory interest, right? Let's kind of slow these down. What's the difference between a fee simple determinable and a fee simple subject to conditions subsequent? The key difference is the automatic right of reversion for fee simple determinable and a right of re-entry for a fee simple subject to conditions subsequent that isn't automatic. The grantor needs to actually exercise his right of re-entry. Let me give you an example. I transfer Orange Acre to Tommy so long as it is used as a church, right? If Tommy changes it or whatever, it'll automatically revert back to me. If I'm deceased, it'll revert back to my heirs, right? It's so long as, until, while. For the purpose of is not effective for determinable language, for durational language. It has to be so long as, until, while. It has to give true duration. So it signifies if that duration ends, it will automatically revert back to the grantor. Fee simple determinable. Is it subject to rule against perpetuities, which I'm going to talk about? No, because either it will be the fee simple or it will revert back. There's no unknown, right? If the event happens, it automatically will revert. Now, fee simple subject to conditions subsequent, right? But if A gets married, then Tommy has the right to re-entry, right? It's going to be similar to determinable, but it's not durational language, it's conditional language. And the conditional event will give the grantor the right of re-entry. Are we clear with determinable versus condition subsequent? Just make sure you know automatic right of reversion, right of re-entry. And then finally, fee simple subject to executory interest. Now this word executory comes in, it's tough, right? Because we see it in contracts and executorship. Well, that kind of means a similar concept in that an executor is a third party. When we think of executory interest, we want to think of third parties, right? So A to B, but if some event happens, then to C. C would have that executory interest, right? They're potentially going to get the property. Now there's a difference between a springing and a shifting executory interest. And let's try to remember this. A springing executory interest will spring from the grantor to a third party. To have a piece of land. I'm going to keep calling it Orange Acre because I think the use of the colors in the acres has some bad meaning to it. I'm going to use Orange Acre. So Orange Acre, I convey it to Tommy when he gets married, right? Now, Tommy is not married. When Tommy gets married, the interest in Orange Acre will spring from me, the grantor, to Tommy. That's what a springing interest means. It springs from the grantor to the third party upon the event. Now here's a different one. A to B, but if B marries a Dallas Cowboys fan, then to C, right? A to B, but if something happens, then to C. It's going to shift from B to C. It's not going to spring from A, the grantor. It's going to shift from a grantee to a third party. Concept there, springing versus shifting executory interest. Ooh, Sam is joining us. Good. Sorry.
Can I ask a question?
supuesto.
You said that executive interest, we have to think third person, but my question is that executive interest a future interest? Is the same?
Yeah, an executory interest is a future interest. It's a third-party interest that is going to take in the future. These defeasible fees are fee simples that might be subject to something happening. They're not complete like a fee simple. They're defeasible. They could be defeated and they could be divested. That's the best word, is divestment. So who could divest? A third party. If a third party is going to divest, that's an executory interest. If the third party is going to divest from the grantor, it's springing. If the third party is going to divest from the grantee, it's shifting. These ones right here are going to be from grantor to grantee. These are two-party fees, where this one is actually going to have a third party involved.
So all of them have in some way a future interest, one of the parties.
Yeah, because all of the defeasible fees have a potential future interest.
Okay.
Absolutely. That's a beautiful statement. Fee simples, there's no potential future interest unless I convey it or it passes through my will or something like that. Defeasible fees are like things, triggering events. That's what I'd like to use, triggering events. All right. Look, these good concept. I feel like people struggle with this a lot and it's not really tested that much, but still it is tested a little bit. So you got to start with it and you got to know it. You got to know everything, in my opinion. All right. Life estates. Now, I had to search far and wide to get the true answer to this because it's such a question that people get wrong. Who has to pay the taxes in the mortgage, the life estate or the remainder man? I finally got it. Bright line rule. The life estate tenant pays the property taxes, the insurance, ordinary maintenance, and the mortgage interest on the property. The remainder man is simply responsible for the principal of the mortgage payments. And that makes sense if you think about it, because taxes and interest and maintenance, those are living expenses. Those are things that need to be paid year by year. The mortgage goes more towards the ownership of the property, right? So just remember that the principal is paid, the principal of the mortgage by the remainder man. Everything else is paid for by the life tenant. The taxes, the interest, those are the big ones, the taxes and the interest. Who is a life estate tenant? Someone who to A for life, then to B. The big thing that they like to test is that a life estate tenant cannot commit waste. There's affirmative, permissive, and ameliorative waste. Affirmative waste, actual waste, is like punching a hole in the wall. You're just wasting the property. Permissive waste is like you see there's a leak and you just let it leak and get longer. Like you don't do anything. You permit the property to go into disrepair. And then ameliorative, think about this. You build something or you add something that actually adds value to the property. Like I have a piece of land and I build a structure on it. Well, I wasn't allowed to build that structure. That's ameliorative waste. Even though it improved the value of the land, it's still not allowable. Any questions on life estates and what is a life estate? And a remainder man that follows the life estate? Simple. So we have fee simples. We have the fee simple that are defeasible, the three different types. We have life estates. And then after life estates, are potentially a remainder man. And then I want to talk about this topic that nobody likes to talk about. Oh, wait. Yeah, I'll do this first. The rule against perpetuities. I remember when I took the bar exam, February 2017, they told me, whoever was the proper professor for whatever company, oh, don't worry about rule against perpetuities, it's never tested. I said, all right, cool. I go to take my test. The very first question I got was a rule against perpetuities question. And I was like, am I taking the wrong test? Like I thought that this wasn't going to be on it. So like, I don't believe in that, oh, let's not learn things because they're not going to be tested heavily. Like, let's learn them and get that point when everyone else fails. The way for me to describe the rule against perpetuities is the sexy grandma. Now, I thought everyone knew about the fertile octogenarian. Has anyone ever heard of this, the fertile octogenarian? Is that a brand new term to everyone out there?
Yes, definitely for me.
It's new, the fertile octogenarian. Okay, I'm dating myself. I'm old. I learned law from my grandfather. The fertile octogenarian is super classic. example of the law. It's like the fox and the hunter, you know, when you learn property, same thing. But the fertile octogenarian is how people can conceptualize the rule against perpetuities. But then I started realizing that no one knows what an octogenarian is. When I asked my student what it was, he said someone with 8 kids, which is not true. What do you think it is, Grace? You know, right?
It's a person in his or her 80s.
Person in their 80s, right? Okay, that's why I came up with sexy grandma. It's better than fertile octogenarian. So let's explain to sexy grandma and how the situation works. Grandma has a son who's, well, I guess calling her grandma kind of makes it weird. Grandma has a grandson, and that's the only heir, right? Grandma has one grandson, and he is 31. And grandma says, I, upon my death, will give this property to any of my grandsons. Well, I don't want to call her sexy grandma for that reason. Let's just call her sexy old lady. Sexy old lady has a son, and the son is 31. And she makes a conveyance that says, on my death, any of my kids who reach the age of 30 take this property, right? Well, you're thinking, okay, who's the measuring life? The 31-year-old kid. Well, then it's cool. No, because the problem is there's a scenario where she makes the conveyance. The next year, the 31-year-old kid dies. He's gone. The very next year, sexy old lady has a baby. Okay. The very next year, sexy old lady dies. Well, now you have a baby and you have this conveyance that only is going to convey if the son reaches the age of 30. But because he's the only son now, the other son is dead. After 21 years, right? 21 years, you won't know if he's going to reach the age of 30 or not. He could very well die at 28. That's a way of conceptualizing the rule against perpetuities. Is it possible that after the death of the measuring life, the death of the son, that there could be a period of uncertainty for over 21 years, whether it vests or not? People think like, to Tommy when Tommy gets married. Well, that violates the rule against perpetuities because Tommy might not get married for 30 years. No, it's not that. Or that could violate the rule against perpetuities because 30 years go by and then Tommy dies. Okay, well, when Tommy dies, it'll either vest or not vest. It'll either vest because he got married or not vest because he's dead and now there's no way he could ever get married again. That's what it's all about, vesting. So rule against perpetuities applies to contingent remainders, executory interest, and vested remainders subject to open. Those are like class gifts that can keep staying open. No interest in land is valid unless it must vest, if at all, within 21 years of the death of a life-ed being at the time the interest was created. So the process is try to identify the measuring life, and then ask yourself, is it possible for the interest not to vest more than 21 years after that person's death? Again, it's not a common answer. Don't pick it unless you did the analysis I just gave you and the light bulb goes off and you're like, okay, that's a violation of the rule against perpetuities. Any quick, like 20-second questions on rule against perpetuities? It's a very, very difficult concept. Everyone hates it, but it was a password to class today and we're all coming up with rapper names. Does anyone remember what my rapper name is?
Ill something, I don't remember.
Ill-gotten gains.
Ill-gotten gains.
Ill-gotten gains. Yeah, Sam was here yesterday. Sam's name was, I love it, Attractive Nuisance, and her album is Broken Trampoline. Pretty good. All right, let's go back to this one, tenant types of tendencies. Yeah, ill-gotten gains, I love that. All right, tenancy in common, JTRS, joint tenancy with the right of survivorship, tenancy by entirety. Okay, tenancy in common is default, what we're going to assume. Grace and I are tenants in common. Something happens to me, then my heirs will take. Grace and I are joint tenants with the right of survivorship. We must have the 4 unities, time, title, interest, and possession. Look out for that. If they say Grace owns 66%, Andrew owns 33%, or Grace takes in February, Andrew takes in March, that's not going to be JTROS because they have to have the 4 unities. Now, they won't tell you if a strong man is needed to, they'll tell you if they have a strong man is necessary or not, but who knows what a strong man is? I'll tell you, a strong man is a third party that is used to convert a JTROS into a tenancy by the entirety. Meaning we have, not a JTROS. let's say I own a home and then I get married to Grace. And traditionally, that wouldn't create a JTROS or tenancy by entirety because Grace and I did not take my house at the same time. So traditionally, if I marry Grace and then I want to start a tenancy entirety with her, we would have to convey the property to a straw man, and then he would reconvey it back to Grace and I to satisfy the 4 unities. Most states have done away, including Florida, with the need for a straw man. So just, vocab word I want to explain, but we understand tenancy in common. The heirs will take joint tenancy with right of survivorship. If Grace and I are JTROS and something happens to me, Grace will survive me. And then tenancy by entirety is just a JTROS with the additional element of marriage. Now, an important point I note is concurrent owners have a right to use and possess the whole. So if 3 tenants in common and 1 rents the house, the other 2 have the right to live in the house. If they are denied this right, it's considered an ouster. That's a tough question to pick because you look at it and you're like, wait a minute. A, B, and C are co-tenants. A rents out the house to Tommy. B and C find out what are their rights, and they give you collect money, no. The answer is B and C get to move in the house with Tommy, and Tommy's like, what? And you're like, yeah, dude, we own 2/3 of this house. That's the rule there. So don't be afraid to pick that answer. You do have a right to inhabit the house. So some key concepts we've gone over so far, fee simples, feasible fees, life estates, remainder men, rule against perpetuities, and then joint tenancies. Everyone with me so far? So far, so good. I'm not gonna do rule against perpetuities twice. Okay, freehold estates, which are also known as leases. Leases is both a contract and a property interest in land. There's a lot of duties, but the main duties of the tenant are to pay rent and avoid waste. The main duties of the landlord are to maintain the premises, mitigate damages, deliver legal and actual possession in most jurisdictions, and duty to repair. There's a question that says there's a holdover tenant, and the landlord, the jurisdiction finds that the landlord's not at fault, even though there's a holdover tenant. And the reason is because in that jurisdiction, they only have the duty to deliver legal, not actual possession. Most states, they have a duty to deliver legal and actual, but remember when you take the MBE, they give you in this jurisdiction or in that jurisdiction, or the answer assumes this jurisdiction. There's differences. So I want to, give everyone the little insights that I have. What are the implied landlord duties? I didn't put it on the slide because they're implied. See, I am a rapper. What are the implied duties of landlord? Anyone know?
Warrant of habitability or quiet enjoyment?
Yes, absolutely. Quiet enjoyment and habitability. Excellent. Excellent. Okay, now we have different types of tenancies, and I'm not huge on mnemonics, but someone gave me a mnemonic that I'll never forget. Your period will suffer. And the reason I like that is because I like mnemonics where the word and the word are similar, period, periodic, will, suffer, suffering. That makes sense to me. If you made it young people want sushi, that would make no sense to me. But when it's your period will suffer, I'm like, okay, periodic, at will, sufferance. I do like that. So tenancy for years, it doesn't have to be for 1 year. It's just a fixed period of time. Periodic tenancy is month to month, week to week. Tenancy at will, you can terminate at any time. And then tenancy at sufferance is a holdover tenant. The key thing is usually when there's a periodic estate, a periodic tenancy, the notice is how long you have. If it's week to week, you have a week to give notice. If it's month to month, you have a month to give notice. If it's not stated, then it's usually based on payment terms, right? If we don't know what it is, but you're paying every month, then you probably have a month to month. Something that's important, I think, is assignment versus sublease, right? The difference between an assignment and a sublease is an assignment is for the remainder of your term. A sublease is for the summer. You're a student and you sublease it for the summer. The key to this is the question that you're going to see on the MBE is if it's an assignment, that person is taking over the remainder of your lease. That person is now in privity with the landlord. And if there's a breach, then both the new assignee, the original lessee are in privity with the landlord and can all be found liable. If it's only a sublease, if I grant Grace 2 months in the middle of my yearly lease, then Grace is in no privity with the landlord, and the landlord can only collect from me. Everyone cool with that? Cool as the other side of the pillow?
Yeah, I if I may add, the original lease is in privity with contract or in contract with the landlord, and the other one, the one that is assigned, the assignee, I think it's the name, it's in privity in state. So that's why.
Right.
It's just that one of the answers, I did a question that would say those terms, and
No, that's fair. The new assignee is not in privy of contract. He was not mentioned in the contract, but now he's in privy of estate with them. Yeah, excellent, Grace. I love helpful pointers from the class. All right. Land sale contracts. All sales for land must be in writing in order to conform with the statute of frauds. Always, like, literally, this is what is a true fact about an MBE real property question. They give you 3 paragraphs, a whole page, and one sentence said it was oral at the beginning, and it's just, this is not valid because it was oral, right? Like, maybe there'll be some performance that overcomes the statute of fraud, but look out for that. It does need to be in writing to conform with the statute of frauds. We have the doctrine of equitable conversion, where during the period of escrow, after the land sale contract, but before the deed delivery, the buyer is the equitable owner and bears the risk of loss unless explicitly contracted otherwise. So we understand that concept, equitable conversion. Grace and I are doing a deal, and I sell her my house, and the closing is going to be in 30 days, but we sign the contract today. Perfect. 1 week later, the house burns down by fire. Who is going to bear the risk of that loss? The buyer, under the theory of equitable conversion, after the contract was signed, but before the closing during that period of escrow. Now, if it says in the contract during the period of escrow, the seller remains liable, like, that's a different thing. In contract law in general, you can pretty much always explicitly contract out of things, almost always, but if it's assumed that we're going to use the doctrine of equitable conversion. All land sale contracts come with the implied guarantee of marketable title, so there's no encumbrances on the land. I didn't go too much into the different types of deeds because we could talk about it, but title is a legal position of ownership, while a deed is a legal document that grants title. Does that make sense? You could have title by adverse possession. You could have title by other forms. Title is just a position of ownership. What do you want? You want a deed. A deed will give you title. There are 3 types of deeds. I didn't put this on my PowerPoint, but just so you all know, there's 3 types of deeds. There's a general warranty deed, there's a special warranty deed, and there's a quitclaim deed. A quitclaim deed is, no warranties, just whatever, implied guarantee comes with it, marketable title, but no warranties about the property. The special warranty deed only warrants to the condition of title while the person owned the property, right? It's not down the chain of title. I don't know if there were deficiencies before I owned the property. I'm only warranting that when I had the property, these things are legit. And then general warranty deed, that is the most legitimate warranty deed that you can get. That warrants through the beginning of time that there is proper title. And there's 6 different covenants. There's present covenants and future covenants. And there's a tough question on there where someone tries to sue on a future covenant. When someone tries to sue on a present covenant months later, and they can't do that. You can only sue on the present covenants when the contract is completed. After that, you can only sue on the future covenants. So the present covenants are sizing, the right to convey, and the right against encumbrances. Those are the present covenants. The future ones are the right to quiet enjoyment, further assurances, and general warranties. That right to quiet enjoyment comes up. Like, you can't enjoy your house because, there's some imposition on your property or something of that nature. So kind of understand that general warranty deed has 6 warranties that can be present and future. Special warranty is only going to warrant for the time you had that title. And then the quitclaim deed is just like, I hope it's okay. There's as is sales, there's caveat emptor, buyer beware. even if it's an as-is sale, buyer beware, it's actually a Florida case that determined this, Johnson v. Davis. There is a duty in residential property to disclose latent defects, right? So like if I know that there's something wrong with the house and I don't disclose it, and it's a residential property, that's it's Johnson v. Davis. That's a failure of a duty to disclose. There's always a duty to not misrepresent. That's another thing. Real property and contract law are in a lot of ways the same. I mean, my uncle, I don't know if I would call him a property attorney or a contract attorney. He would probably call himself a contract attorney. He would really call himself a construction law attorney, right? Construction law, contracts and real estate. And they deal with a lot of these issues. So there's a huge overlap between real property and contract law, which is fair because, you know, you can think about it rationally. Whereas civil procedure and evidence, you're sometimes like, that doesn't make sense, but it's like, yeah, but that's the rule. Here, the rules make sense. The rules were created. I'm not saying they don't make sense in civil procedure, but in procedure, the rules are made for the sanctity of the court. In contracts and real property, the rules are made for business, right? So that things can effectuate smoothly. So always use your contractual business mind when you're in real property to determine how should this operate and what's going on here. Deed by estoppel is an interesting thing that actually isn't so logical. Or estoppel by deed, I think is how it's actually called. Basically, let's say this. Grace and I are friends, and I want to give Grace this house, but it's my mom's house. And I say, Grace, here's a deed conveying my mom's house to you. You can have it. And she gives me, you know, some money or something, right? Or not even money. I just give it to her. I convey a deed. I record it. I give her the deed. But it's not my house. But then later, my mom gives me the house. Well, I will be estopped from denying my earlier conveyance to Grace. So the moment my mom gives me the house, it will reactivate the valid conveyance that I made to Grace before. Even though I didn't own the house when I made the conveyance, because I later subsequently get ownership and the right to convey, I'll be estopped from denying the earlier conveyance. Look out for that one. It definitely comes up, estoppel by deed, where you're like, who owns this property? And it's like, Tommy transferred it to Johnny, then Tommy transferred it to Johnny, then Tommy became the owner of the house, then Tommy transferred it to Michael. Well, it would go to Johnny, not Michael, because Tommy transferred it to Johnny, then got ownership of the house, estoppel by deed. So the subsequent conveyance to Michael is he didn't have it anymore. It was Johnny's. Does that make sense? Estoppel by deed and how you can reactivate a conveyance that you didn't have the authority to make at the time. Look out for that. It definitely, like I could guarantee, I bet my bottom dollar, just like I could guarantee that the Eagles were going to dominate the Giants last night, I could guarantee that you're going to see this question about deed by estoppel on the test.
Doesn't matter if the closing date already passed or I think there's like a reasonable time after the closing date, right?
Certainly, there's always a reasonable time after the closing date for any issues in real property, unless time is of the essence, unless they state in the contract that time is of the essence. So then the last thing on this slide is an action to quiet title. That's the appropriate when there are conflicting claims on a property, right? You'll bring an action to quiet title. People will say, I have title, I have title, I have title. Who really has title? A lot of it's going to come down to being a bona fide purchaser in a pure notice jurisdiction or in a whatever notice it may be. They're definitely going to give you questions on the test, long questions where then they give you the statute. We don't know. Like I told you, you can assume joint and several liability and pure comparative negligence in torts. There's no assumption on what notice statute you're going to use in real property. They will literally give it to you every time. And the language is clear. If it just says without notice, it's pure notice. If it just says first recorded, it's pure race. If it says without notice and who's first recorded, then it's a race notice statute. The easiest one, because I live in Florida and I just understand it the most, is pure notice. Florida's a pure notice jurisdiction, which means the subsequent bona fide purchaser will always prevail. Can anyone tell me what it means to be a bona fide purchaser?
Yes, it's the person that buys without notice of the previous conveyance, and for value.
And in good faith.
Oh yeah, good faith.
Can someone not named Grace answer the more difficult question here? What are the different types of notices? How could you have notice?
Actual notice, constructive notice, and inquiry notice.
Perfect. Actual notice, constructive notice, and inquiry notice. Constructive notice would be like record notice, where it's in the deed, you just didn't look at it. Actual notice is like you literally knew about it. And then inquiry notice is a common one that comes up on the test, where it's like Tommy had no idea it was ever recorded, and Tommy had no idea that Brandon owned the property, but Brandon was literally living on the property and like having, you know, play dates every day. Like you could have visited the property and seen that Brandon had possession. That's what inquiry notice means. So pure notice just means if you're a bona fide purchaser, you took for value in good faith without notice, then you're always going to prevail. It doesn't matter. Erase notice means you have to be a BFP and you have to be the first to record. So the first BFP to record will prevail. And then erase statute, it doesn't matter if you're a BFP or not. It's just whoever records first. It's the first to record, erase to record. So you see in a pure notice jurisdiction, it doesn't really matter who records first. It matters who became the bona fide purchaser first, right? In race notice, it matters who became the bona fide purchaser and recorded first. And then race notice is just who recorded first. Those are tough questions, but like not really actually. If you just understand what the statutes mean, you can identify the statute and put it to use. And then what Claudio said was excellent, that there's different types of notice: actual notice, constructive notice, and inquiry notice. Any difficulties so far? One thing I didn't mention on this PowerPoint, and you know, I can't mention everything, but throughout it's not on my PowerPoint. In the folder, there is everything. But one thing I didn't mention on this PowerPoint is lien theory versus title theory. Lien theory is like Florida. Title theory is like California. Lien theory means that if there's a mortgage or encumbrance on the property, it will not sever the JTROS, and they can't, you know, foreclose on the property because there's another person. A title theory means that they could. If someone has a mortgage on the property, they actually have title to the property and they could foreclose. So they'll tell you if it's a lien theory state or if it's a title theory state and what that may mean. But I just want to get that. I felt like now is the time to talk about lien theory and title theory. All right, mortgages. Every time I have heard from students about the test, a lot of it's about mortgages. I really didn't expect that many questions on mortgages. Wow, they really were asking a lot about mortgages. And it makes me want to slow down the conversation and teach everyone what is a mortgage and how do mortgages operate. A mortgage is a security interest and it's a loan, right? It's a debt that needs to be repaid. So if you study commercial paper, you know what a loan is: a promise to pay someone back money plus interest. If you study secure transactions, you know what a secure transaction is. It's something that's collateralized by equipment or inventory or something like that. Mortgages is that combined process in property law, right? Where we will allow people to take out money, and if they don't pay us back, then the lender has rights in the property as collateral. That makes sense? A mortgage is a collateralized loan and the collateral is property. Simple as that. There's a Andrew said Philly was gonna, I just saw this. Every one of my students, I told him the Eagles were gonna win by 50. And if you looked at the math, they were up by like 28 at one point before halftime. They were going to win by 50, but they took it, whatever. So mortgages are a collateralized loan and the collateral is the house. And when we think about a mortgage, there's a very important type of mortgage. It's called a PMM, a purchase money mortgage. A PMM is just like a PMSI in secure transactions, if anyone remembers what that is. When I teach secure transactions, I'm always like, this TV behind me. If someone lent me money to buy the TV, and if I don't pay them back, they get to take the TV, they're gonna have a PMSI. The money that they lent is used to buy the collateral itself. That's what a PMM is in mortgage law. If someone lends you money, a bank, and you use that money to buy the house, happens all the time, then the bank has priority over all other mortgages, right? to remind people, the mortgagor is the individual who takes out the mortgage. The mortgagee is the lender or the bank. The PMM is the priority mortgage. So any other mortgagor will take junior precedence over the PMM. Otherwise, it's whoever was first in time, first to record. That'll be the priority mortgage, whoever perfected it, right? There's a concept of an equitable right of redemption and a statutory right of redemption, because I always think of him, and I might be dating myself with this movie, but Happy Gilmore, where he was he was a hockey player, and he was trying to win his grandma's house back by playing golf, and that's like the whole point of the movie. But basically, it was announced that the house was under foreclosure. If Happy Gilmore would have made the money playing golf and bought the house back before the sale, that's equitable right of redemption. We can assume equitable right of redemption. Some states have a statutory right of redemption, which means even if they would have sold Happy's grandma's house to Shooter McGavin, he would have had a certain period after the sale to buy it back. That's the statutory right of redemption. So some good vocab words. Mortgage is a security interest in land. It is a debt that is mortgaged by a property. In the event that a mortgage fails to make payments to the mortgagee can institute a foreclosure action, right? And a foreclosure action will extinguish all junior interest on the property. If we have a foreclosure, they sell the property, and there's still people who have rights in the property but didn't get paid, they'll have to seek a deficiency judgment. A deficiency judgment can also be sought by the mortgagee if the proceeds from the foreclosure don't pay off the loan. Happens all the time because interest rates, right? So these are just some concepts that I want to look out for and know about. This, again, just like I can guarantee that the Eagles are going to beat the Cowboys or the Niners, is going to come up in your test. Subject to or expressly assume. And it's complex, but I'll make it simple. If someone takes subject to a mortgage, that means the original mortgage holder, the first person, like bank, Andrew, Grace, these are the parties. Andrew is the mortgagor, bank is the mortgagee, Grace is the person that I'm going to transfer my property to. I took out a mortgage from the bank. Now, if Grace I transfer my property and she takes subject to my mortgage, that means I am still primarily personally liable on that mortgage, right? She might be a surety, secondarily liable, but I'm still primarily liable on that mortgage. Now, if Grace expressly assumes, you see that word, expressly assumes, that means she will assume primary and personal liability for that mortgage. But me, am I off the hook? No, I am still secondarily liable as a surety in case Grace doesn't pay. There's only one way to completely get off the hook of a mortgage. Does anyone know what that's called? What's it, Grace?
Novation.
Novation, excellent. A novation. And novation is a complete substitution of the parties. Brings us back to contract law, right? Where we have delegation of duties, assignment of rights, novation, complete substitution of the parties. I can't stress enough that contract law and real property law are entangled. Entanglements with August. If anyone knows what that means. All right, easements. Easements are pretty easy. Easements, right? Easement is just a right to cross, a right to access. I just want everyone to know the different types of easements. Express, written, implied, is not written. Easements will run with the land, right? So if Grace has an easement to use my to walk over my property, and then Grace sells her land to Tommy, Tommy will inherit that easement. It will run with the land, unless there's some termination event where it's completely terminated. One way that you could see termination is by merger. So check this out. Grace and I are neighbors. Grace has a little traverse over my property, and then I buy Grace's property. Now I own both properties, and then I sell that property to Tommy. Tommy no longer has that easement because I have successfully merged the two properties through concurrent ownership. That's the only way that we could see that. The concept of merger also comes up in real property, where a contract will merge into a deed. I like to remind people of words that we see in different places that actually have different meanings. But merger can mean the terms of the contract merging into the deed, and you can only sue on the terms of the deed. Or merger could be the concept of an easement being terminated by a person buying the property, by the adjoining ownership of property. So we have express, implied, a pertinent is dominant and servient versus a gross. A gross easement is personal. It will not run with the land. Think of a gross easement like a utility pole, like Florida Power and Light, FPL calls me up and says, Andrew, we want to put a pole on your house. They can do that potentially, but it's gross. It doesn't run with the land. It's not dominant and servient. When there's a dominant and servient estate, the dominant estate is the land that's, the estate that gets to use, that gets to walk over, right? And if they're using it, then they have the duty to repair it. They have the duty not to overuse it or abuse the scope of it, right? Easement by necessity, when one parcel cannot access a public road, you'll have that easement by necessity. Easement by prescription is just like adverse possession. There's a statutory period, it has to be open, it has to be adverse, it has to be notorious, it has to be hostile, has to have all those elements except exclusivity. So think about that. Easement by prescription is when you earn the right to an easement based on squatting on it, but it doesn't have to be exclusive. Grace and I can both earn the same easement over someone's land. If Grace and I were trying to claim adverse possession, there would have to be that exclusivity element because only one, party or joint party can have title over a property. So easement by prescription is basically squatters' rights to get an easement with no exclusivity. Affirmative easement is a right of access versus a negative easement is a right to restrict someone. It's pretty hard to get a negative easement. A remedy for overuse or violation is injunction. Any questions about easements? Easements are easy. Adverse possession, they'll typically say like, la, 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 if the court finds that possession is for Andrew, why? Andrew possessed adversely. They'll give you the statutory period. I squatted on it. It was continuous. It was open and notorious. It was actual and exclusive, and it was hostile. They didn't have any permission to do what I was doing, and I squatted on it. Something I did learn about adverse possession, I always want to learn new things. Let's say Grace and I acquire property by adverse possession as joint tenants. Her and I are joint tenants. And then I die. Who has title to the property after we've acquired through adverse possession? Just Grace or Grace and my heirs?
No, me, because it's right of survivorship, right?
No, we're tenants in common, not JTROS. You and I are tenants in common. We adversely possess the property as tenants in common, and then I die. The answer is my heirs.
Yeah, your heirs.
Think about it. Even if you got adverse possession, it's still title, right? It's just not by deed. So it's still going to operate the exact same way. So these are some good issues: adverse possession, easements. I think this is the last thing I've talked about yet before we take our break. Real covenants and equitable servitudes. I could have gotten down into the deep nitty gritty about what's required to run with the land, the burden versus the benefit, when do you need horizontal versus vertical privity. It's a little bit convoluted. It's not heavily tested. So I kind of want to step away from it and just make sure that everyone understands what covenants and equitable servitudes are. And it's confusing because they can literally on the MBE call an equitable servitude a covenant, right? Like even though real covenants and equitable servitudes are different concepts, they actually use the words interchangeably, and that's annoying, but it's just something you have to accept. But look through the answer and understand what the truth of the matter is. Covenants are remedied by monetary relief. Equitable servitudes are remedied by injunctive relief. I have an equitable servitude in my townhouse association. All of our doors have to be painted blue. If I went outside and painted my door green for the Eagles, what would they hit me with? An injunction. I had to paint it right back. If they said, it's monetary relief, then that could be a covenant. But covenants, they need to touch and concern the land. There has to be intent. There has to be writing, and they'll usually run with the land. Covenants can also be implied if there's a common scheme or plat, right? If there's a subdivision and everyone else has the covenant, then it can be assumed that you have that covenant too. But that's just kind of what covenants and equitable servitudes are, and they can indeed run with the land. So I'm gonna go ahead and stop the presentation right now. When we come back from the break, we'll go over the cram guide pointers I have on the PowerPoint, and then we'll really go through the materials I have and make sure that everyone feels really good about real property, so that when we come back this afternoon to do the questions and answers, we get as close to 100% as possible.